anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open.
Good morning.
Good morning.
Thank you so much for your patience. We apologize for some of the technical difficulties that we experienced this morning. And certainly if we experience any throughout the course of our hearings, we'll have to pause, obviously, to try to get those rectified, but we have some very able staff on hand to assist us with that, should that occur. Our first case, we're going to try to keep things as normal as possible, hence the cry. Our first case on the docket is 19P1351, Commonwealth v. Mr. Attorney O'Brien. OMONKHEGBE. I apologize if I'm butchering his name. My name is Justice Desmond. Also on the panel today is Justice Ditkoff and Justice Singh, and will be your panel for this morning. So with that, Attorney O'Brien.
Thank you. I was going to ask for where the time was. Thank you. I see it. Good morning, Your Honors. As you know, I represent the defendant in this case. There are two issues. The first, and I think strongest issue, is with respect to a lesser included instruction that was given to jurors. Despite that there was no evidence to support that the defendant was armed, the judge took it upon herself to instruct jurors on the lesser included of unarmed robbery. And
now, it's true, Attorney O'Brien, that the jury was instructed on the lesser included unarmed robbery. Is that correct?
Yes, they were. No one requested it, but they were instructed on it. It was not on the verdict slip.
And there was a instruction conference where the judge had reduced her proposed instructions to writing and shared them with the lawyers prior to actually instructing the jury. Is that fair to say as well?
That's fair to say, yes.
And in both of those instances, either at the conference or with the written submission from the judge, there was no objection to giving that instruction. Is that right?
There was no objection, and it also wasn't discussed, nor was it requested by either the Commonwealth or the defense.
Okay.
Yes. So in this argument, I'm also arguing that there was an ineffective assistance for defense counsel's failure to object. And I know normally that's brought by way of a motion for new trial, but here I think it's very clear on the record, because defense counsel did file to set aside the verdict and to stay the sentence after the verdict came down. And he states very clearly on the record that his failure to object wasn't tactical, but it was due to, and I quote, consuming nature of the instructions, which were not separated by individual subsections. He told the judge that it was inconspicuously tucked in the back of the armed robbery instruction. It was exacerbated by the fact that he got the verdict slips in advance, and on the verdict slip, it also did not reference unarmed robbery. So I think it's clear in this case that it wasn't a tactical decision, that he complete oversight, and Your Honor is correct that he did have the opportunity to object to that when either the judge read instructions or them to counsel in advance, but he failed to do so. And I would point out that even though he failed to object, that's really not what the case law turns on. It isn't required that.
I'm going to interrupt you for one.
Yes.
Attorney O'Brien, I'm going to interrupt you because I think Justice Ditkoff was trying to say something, but I can't hear him.
Counselor, by any chance, have you read the Rodriguez case, 462 Mass 415? It's a lesser included case, but the only one I could find where there was no objection. And in there it holds there's no substantial risk of miscarriage of justice because this instruction gave the defendant a benefit to which she was not entitled. And so I'm wondering, what's your argument that you have a substantial risk of miscarriage of justice, or that this deprived your client of substantial ground of defense, where it enabled him to be convicted of unarmed robbery, where your basic theory is that the jury had to convict him of armed robbery?
Well, it allowed jurors to convict for a crime that there was no evidence. And I think whether or not, regardless of whether or not there's an objection, I think the law is clear that jurors shouldn't be permitted to convict somebody on a case, I'm sorry, on a crime for which there is no evidence. And if you look at the evidence here, there is no theory that the Commonwealth, that the jurors could have put together facts-wise to show that the defendant wasn't armed. I'm sorry.
Let's say
Yes.
Can you hear me?
Yes?
Yes.
Well, you say there was no evidence of unarmed robbery. Certainly, the jury could have disbelieved whatever testimony was given regarding the presence of a gun or the use of a gun in the commission of these offenses.
Well, I know that this case law, and the Commonwealth pointed this out in their brief, that jurors are obviously free to believe parts of the evidence, not others. If one person testifies to one thing and another person testifies to a different thing, that's appropriate, obviously. But here, I think the argument is that it was consistent. So even if the jurors pick a piece of testimony from one witness and a piece from another, if those are consistent and they are the only evidence that was presented, then there's really no evidence to support that. Here's testimony that there were essentially 6, I believe, total. And the Commonwealth points out that the father, in this case, Robert, he initially said there were 4, or he testified there were 4 to 5 individuals who he's observed on the porch that were breaking in. And even if the jurors believed that there were 5 people there instead of Derek's testimony, which I believe he ultimately locked into 4 people, and Peralta said there were 4 people. Even if we were to believe there were 5 people, there is only evidence to support that there was a firearm when they smashed the back door. I think this is a very important part of the case, because the Commonwealth tried the defendant under the theory of both principal and joint venture.
Weren't there also other weapons involved? Weren't there hammers and a taser? And weren't there other weapons involved?
Hammer, tase, 2 hammers, taser, pellet gun, regular firearm, bolt cutters.
Right, and the judge instructed on joint venture. And
Yes.
wasn't your client's defense, I wasn't there at all.
Yes, that was the
So
defense.
if that's the defense, how could it be prejudiced by an unarmed robbery instruction? If the defense is, I wasn't there, either you believe me, I wasn't there at all, or you believe the government I was.
He was prejudiced because he was found guilty of unarmed robbery, and there was no evidence to support that it was unarmed robbery. If he was part of a joint venture and there were 5 people on the porch, the sliding glass door was smashed in by a gun. So that firearm was present for the 4 or the 5 people when they initially entered the residence. So there's no way he couldn't have had knowledge that at least one participant had a weapon.
My understanding is, however, that the judge didn't really instruct the jury as to his knowledge about the other weapons. And so if the jury believed that nobody puts a weapon in your client's hand, what are they to do?
Well, the law is still that it's an element that the defendant have knowledge, that it's an extra element, if you will, that the defendant have knowledge that one of his co-venturers has a weapon. Just because the jurors weren't given that instruction doesn't mean that that isn't applicable to an armed robbery. And I would argue that the instruction, it could have been an oversight, but it looks to me like it wasn't given because it was so obvious from the evidence that the defendant was personally armed. When they described who was involved and what they looked like, and even the Commonwealth argued this in its closing argument, that the defendant was one of the individuals who was dragging the victim around with the hammer or the gun, and dragging him around from room to room. Peralta walked in and said the defendant was tussling with Derek and that one of them had a gun and the other person had some other kind of weapon. There were weapons present everywhere. If he was inside of that house, he had to have seen a weapon, whether it was breaking into the house with a gun, smashed the door, or whether he was inside when the victim was initially tased or
That's
hit
not
over the head
enough,
with a
right? It's not enough that he saw a weapon once he's in the house. He has to know that they're armed going in. Isn't that right?
Well, he has to know that, not necessarily going in, which I would argue he did know they were armed going in. If he was one of the 4 to 5 people on the porch and a gun was used to smash the glass, then he certainly knew right off the bat that there was a gun. There was some sort of weapon. But when they went in and he was participating in the robbery, there's no way he didn't know that there was because it continued over time. It wasn't a quick entry, rob a store, run out. This went over, a period of at least 10, 20 minutes, I believe.
Jury,
Judge
I'm sorry.
Ditkoff.
if the jury disbelieves the details given by the victim, but believes the text messages, was there anything in the text messages that required the defendant to understand that there was going to be weapons used in this?
There was nothing in the text message that referenced weapons. And Peralta testified that he didn't know that weapons were going to be used. But again, when they first entered the house, and this was uncontested testimony, that there was a gun. So right from the outset, there's a gun present. There's no evidence the defendant withdrew from this joint venture. He went in with the gun and he stayed in the residence the entire time and took off when his co-venturers took off. Sure.
In Nardone, the remedy for this kind of error was a new trial on the greater offense. And in Poro, the remedy for this kind of error was no new trial at all, at least on the theory in question. So which is it? If you win, is it a new trial on armed robbery or is it an acquittal? And why?
I would say it's an acquittal because the defendant had already been found not guilty of the greater offense. So double jeopardy would apply to that. As far as the lesser included offense, since there's no evidence to support that, even viewing the evidence in a light most favorable to the Commonwealth, no reading could support that I think it should be an acquittal.
And what do we do with Nardone saying that where a defendant attacks the very error that resulted in his conviction on the lesser offense rather than the main offense, we hold that retrial on the main offense is not barred?
I mean, I don't know how that seems to fly in the face of a double jeopardy argument where someone is not convicted of the greater offense. But I understand that case. Yeah, I mean, I would stick with my initial answer as far as the double jeopardy, because as far as I know, you can't retry somebody convicted of the greater offense. So I think it should be a not guilty all around. And I understand maybe this was a compromised verdict, and jurors are allowed to compromise verdicts, but when there's no evidence that supports it, it's a clear error, or it is an error. I think it's important too, and I noted this in my brief, that had this been intentional with the judge, it would have made sense that she would have instructed on the lesser included with respect to the assault and battery.
Good thing is
with a dangerous weapon.
Counsel, you're running out of time, and I would like you to address the verdict slip issue.
Yes. The verdict slips issue, I think it was error here because it was not on the verdict slip at all. It was a handwritten write-in, and I understand the judge did give that instruction, but here the I would argue that there's error because the judge failed to follow protocol. And I think the proper protocol is to, inform both attorneys. Oh, I'm out.
No, you're not. That's just
Okay.
minute 20. You got another minute. I don't know.
Okay. It went from one to, yes, to inform both trial counsel what happened, and give them a chance to object or to pull jurors to rectify the situation somehow. Here, the defense counsel had no idea that they had written this in until after the fact. So I think the proper protocol would address that there, make sure this is exactly what the jurors intended, and rectify the situation there. And any doubt or a question about a non-confirming verdict should be resolved in favor of the defendant. So I would again argue that this verdict should be set aside.
The verdict was indeed announced in open court, right?
It was,
And
but
all the jurors, as best we can tell, agreed that that was indeed their verdict when asked by the judge.
yes, but certainly defense counsel should have been made aware that there was something handwritten and crossed off on the verdict slip, because it's not something that's a regular occurrence.
What else would you like to tell us?
How much time do I have?
Couple more minutes.
More minute. I don't know if I have time for the last argument. I would argue just with the last argument, I think the second point is the strongest. I think that here Peralta was a key witness for the Commonwealth, obviously. So he got a deal. And I think it was important that he be cross-examined to the fullest extent possible about his bias. And when he defense counsel was shut down as far as asking what the punishment or penalties were for some of the crimes, I think that was impermissible. It's not the defendant's fault that the Commonwealth chose to charge Peralta and the defendant with some of the same crimes that carried a severe penalty. So the more charges and the more penalties he had, I'm sorry.
Judge,
Wasn't counsel ultimately able to get that answer? I mean, this was just a re-questioning of something that had been previously asked, except this time it was focused more on the specific offense. But what counsel was trying to get across is that these were serious offenses, that now there were no consequences for it. That point got across, right?
It got a point. Yes, it definitely got across. There were some serious offenses, but he should, my argument is that he should have been able to ask them all. And if there were 10 offenses and 3 of them happened to be something that the defendant was charged with, he should have been able to ask about all 10, because the more time that someone potentially faces in jail, obviously, the more reasons they have to come testify and throw somebody else under the bus.
so if he was facing 3 life felonies, the jury should have known that each one was a life felony versus he was just facing a life felony.
Absolutely, yes. I think it helps the defendant if there are 3 possible chances of being convicted for a life felony than just 1 possible chance. Absolutely.
Thank you very much, Attorney O'Brien. I think we'll get it. We get it, and we'll have to leave it there.
Okay, thank you.
ADA Lee.
Good morning.
Morning. What do you say to they should be able to hear about all 3 of the life felonies, or 2 of them anyhow, versus just the 1?
So I would suggest that the jury heard that the cooperating witness avoided armed robbery, which was the same charge that the defendant was charged with, as well as several other lesser crimes and armed home invasion, which the jury knew was a life felony with a minimum mandatory sentence. The only thing they didn't hear is that armed robbery was also a life sentence. Had they been given that information, they would be given evidence that they're not allowed to consider, i.e. the sentence, the potential sentence affecting the defendant. That's not something they should be considering. And you're giving that as evidence to the jury. So the judge was left with, should I let them hear that there's an additional life sentence that the cooperating witness avoided? which means they'll hear evidence they're not supposed to consider about the defendant's sentence? Or should I let it stand as he avoided all these crimes, including the crime the defendant is facing? And in addition to that, one of those crimes was a life felony with a minimum mandatory. The judge is correct in exercising discretion to prevent inappropriate information from getting to the jury, while at the same time, the jury is hearing all the relevant information. When questioning on bias under cross-examination, the judge can exclude materials that's cumulative. Defendant has one life. The jury knew he avoided a life sentence. The important point of the cross-examination is his testimony and his cooperation with the government gave him a great benefit. And his great benefit was avoiding a trial like the one the defendant was facing, avoiding a conviction like the one that was being considered at this trial, avoiding other charges, including a life felony. That's more than sufficient for the jury to make the determination of whether this cooperating witness was biased. And the judge made the right call on this one in exercising discretion. And this is not an abuse of discretion situation, and this court should reject the defendant's claim on that ground. And it's similar to the other claim the defendant makes on cross-examination, which is the questioning on whether there was a beef or an argument or a physical confrontation between the defendant and the cooperating witness. On the first question, the Commonwealth objected. That objection was overruled, and the witness answered, no, there was no physical altercation. Wasn't there an argument? No. Didn't this happen 2 weeks before? No. Then on the fourth question, which was, so you're denying, and the Commonwealth objects, and the judge says, you better have a good basis for this, because the witness had already answered the question 3 times. You get to ask the question, you get to get an answer to the question, but the questions themselves are not evidence, and by allowing repetitive questions with only denials in response doesn't help the jury at all. It just badgers the witness, and that is well within the judge's discretion as to say, that's enough. You've gotten your question, you've gotten your answers. 3 is plenty. And there was no indication that the witness would waver on that. So the defendant's second claim of an interference with the right of confrontation and the right to cross-examine is not supported by the record in this case, and I'd ask the court to reject it. Moving on to the first issue, which is whether there was evidentiary support for unarmed robbery. The Commonwealth first will point out the case law. Commonwealth versus Santos, which is a Supreme Judicial Court case from 2009, was a question of whether there was evidence to support a self-defense instruction. And in rejecting that contention, of the defendant that there wasn't, of the Commonwealth in that case, that there wasn't sufficient evidence for self-defense. It said the contention assumes that the jury could only have adopted or rejected one of 3 versions in its entirety. This is not the case. The jury are entitled to pick and choose among conflicting versions, accepting or rejecting all or portions of the testimony as they see fit. And then again in Thayer, which is another case similar to the claim the defendant is making, the appeals court in Thayer did what that defendant was asking, what this defendant is asking here, to reverse the conviction on the lesser and prevent a retrial on the greater under double jeopardy law. The appeals court did that. That was a case that was charged forcible rape in an intrafamily rape. An instruction on statutory rape was given. The Supreme Judicial Court in Thayer granted further appellate review, and they found, if the jury disbelieved the victim's testimony about the threats of slapping and spanking and getting in trouble, they might still believe that the defendants had intercourse with the victims and abused them. This hypothesis was sufficient to justify the instruction on statutory rape. And so in Thayer, the Supreme Judicial Court reversed the decision of the appeals court and reinstated the conviction for statutory rape. And I would suggest that case, both cases apply here. The defendant realized, oh yes.
I'm going to interrupt you for one moment. Justice Ditkoff?
Counselor, what's your answer to my question about the remedy? Is Nardone or is Poro the right remedy? Is it a new trial or is it an acquittal? If, I mean, I know you don't think she's got anything, but if she prevails on this issue.
If
Prevails.
the defendant prevails, I think there's a real difficulty in this case because the jury has crossed out armed. And so I looked to the Choi case, which I don't believe is cited in the briefs. It's a Supreme Judicial Court case that says if the jury has not made a finding on a theory of murder, that the Commonwealth can go back and retry on that theory where there was no verdict. But in this case, I feel the Commonwealth must acknowledge that the jury here crossed out armed, which supports the defendant's contention of a not guilty finding and would get us into the realm of, double jeopardy. I also looked to, I believe it's the Smith case that went from the Massachusetts Supreme Judicial Court to the United States Supreme Court on double jeopardy when the jury had, the judge had found a not guilty and directed the verdict and then took it back.
So at bottom, you say acquittal if she prevails.
That's what I think what the defendant is asking for is the remedy if the defendant is correct. However, I suggest the defendant is not correct. And I realize sounds like a pretty big concession from the Commonwealth that there's no middle ground here, which is why it's exactly like Thayer. That's why the Supreme Judicial Court took Thayer up. And so you might ask me, well, then how does this case differ from Ortiz, which is the case the defendant relies on in their brief? And it's on the evidence. This case is factually distinct from Ortiz. In Ortiz, there was a question of whether there was anal penetration in a rape case. And the victim was steadfast in her cross-examination that anal penetration had occurred, where the defendant said there was absolutely no anal penetration. Rather, they had other sexual contact that was consensual. So there was no middle ground. In this case, there is middle ground. And that's why we fall under Thayer and Santos. Part of the problem in Thayer was they were children witnesses and in sexual assault cases in an intrafamily rape. And so their discussion of the punishment sounds a lot like punishment within a family, spanking, et cetera. And so that's where the jury could have found reasonable doubt in Thayer. Here, we have lots of inconsistencies, and we have the cooperating witness, Peralta, who says he was not the person with the taser, even though he was identified by the victim as the person with the taser, and the taser is found in his car. Not only is he a cooperating witness, but he's got inconsistencies with the victim and the victim's father. So here, the victim's father said he saw 4 or 5 men and 1 weapon before he ran out of the house as they're breaking in. The victim testified on direct that he saw 4 men, but then he was asked on cross-examination, and this is why it's distinct from Ortiz, didn't you tell the police 7 men? And he said, yes, that's at transcript 2, page 80. I did tell the police there's 7 men. I thought there were 7 men. Now I think it's 4. So we've got that wavering that there could be more people in the house than the cooperating witness is willing to admit, knowing that one of the people he's identifying is his friend, one is his cousin. So under the father's testimony or the victim's testimony, there could be more than the 4 men present. And the cooperating witness is the only person who identified the defendant. He called him Prince. He's the only person who identified the weapon. And his testimony is likewise not steadfast as in Ortiz. He didn't put a gun or any weapon in the defendant's hand. He said he saw the 2 men, one of whom is believed to be V, one of whom is believed to be the defendant. He saw them grab the victim, which is something the victim also testified to, that he saw hands and people were grabbing him and there was so much force that he went down. But on cross-examination at transcript 2, page 125, the cooperating witness was asked if they, and he had been talking about the 2 men with the victim, if they were armed, and he said something, I think it's, I believe so, yes. So that's the best evidence of putting a weapon in the defendant's hands. It requires the jury to draw the inference that the victim and Peralta are talking about the same person. It requires them to draw the inference that I believe so, yes, means definitely yes. And it requires them to believe that there were no other people in the house who might have been the people with the hammer, despite the victim's and the defendant's father, I'm sorry, the victim's father's testimony that there could have been 5 to 7 people. The Commonwealth asked the jury to draw those inferences, and here they did not do so. And on the instructions in this case, which is at transcript 471, the instruction was, if the Commonwealth has failed to prove beyond a reasonable doubt that the defendant was armed with a dangerous weapon, but has proven each of the other 3 elements beyond a reasonable doubt, then you may find the defendant guilty of unarmed robbery. That's the unarmed robbery instruction. And they were never given the option in the joint venture instruction to find the defendant responsible for the weapons held by other people.
Going back for a moment to Peralta's testimony, didn't he initially, or perhaps I'm mistaken, didn't he initially deny some of the weapons? And then weren't they recovered actually in his car?
Yes, that's I believe in reference to the taser. He's identified by the victim as the person with the taser. The taser's found in his car, and he said that he never had a weapon and he didn't know there would be any weapons until he got to the house. And then the weapon he saw was a gun, and he believed the other people were armed. So his testimony suffers from believability issues, not just as a cooperating witness, but inconsistencies with the other evidence, which throws us right into the realm of fair. The Commonwealth acknowledges an error on the verdict slip. The verdict slip should have matched the instructions. It did not. The unarmed robbery was not on the verdict slip. So the jury crossed out armed and wrote in unarmed. They were following the instructions. This shows a smart jury that's listening to the instructions and knows its legal options and convicts the defendant of a crime. This case is not like Zacharias, which is a Supreme Judicial Court case on error in the verdict slip. In Zacharias, the jury came back with a negligent assault and battery. And that was an ambiguous verdict because negligent assault and battery is not a crime. So they convicted the defendant, Zacharias, of nothing. And so the judge asked a question, do you mean reckless assault and battery, which is a crime? And the the Supreme Judicial Court said, that's not okay because it sounds like the judge is trying to convince them of an actual verdict of a criminal offense. What should have been done in that case is vacate that verdict as ambiguous, re-instruct, send them back and get a new verdict. Here, we have a verdict that convicts the defendant of a crime that is a lesser included offense that is supported by this evidence that the jury were instructed on. So it's not ambiguous, and Zacharias is an opposite. I admit there are not a lot of error in verdict cases, which is good. It shows that the courts are being very careful in those. The only other point I can think to bring up is the ineffective assistance of counsel. The judge, after the verdict, said that the instruction would have been given even over objection, and so there's no ineffectiveness because there's no prejudice. I see my time has expired.
Well, we'll certainly afford you another moment or two if you wanted to say something additionally, given we started a little bit late and we extended the same courtesy to your sister.
Unless this court has any questions, I would just ask that you affirm the conviction in this case because a reversal with no chance for a retrial would not be justice in this case. The jury made a correct verdict on the instructions and the evidence here.
Thank you. Any other questions from the panel? I think we have it. Excellent job by you both. Thank you kindly. Appreciate your patience. Case is submitted.
So So I'm just gonna call Patricia because I believe that we may have a problem with the